Trump's tariff wall just cracked, and the crack came from a toy store. Not from Canada, not from the Supreme Court, from a man who imports Lincoln Logs and Tonka trucks. And what happened next in that courtroom Thursday night changes everything about the next 53 days. Here is what you need to know right now, and why the mainstream news is already burying the part that matters most to Canada. On Thursday evening, the U.S. Court of International Trade issued a 2-to-1 ruling striking down Trump's 10% global tariff, the one he built specifically to replace the tariff the Supreme Court already killed in February. The court found he had no legal justification to use Section 122 of the Trade Act of 1974 for a blanket global tariff. The tariffs must stop, refunds must be issued, and Trump is now running out of laws to hide behind. If you want the real story behind every ruling before it gets buried, make sure you're subscribed and hit the bell. We break this down daily, not when the algorithm decides you should know. Go back to February 20th. The Supreme Court ruled 6-3 that Trump's IEPA tariffs, the sweeping emergency powers that hit nearly every country on Earth, were flat out illegal. A 1977 law was never designed to do what Trump tried to do with it. The court was clear. Trump responded the same day. He signed a new executive order, new law, new legal hook. Section 122 of the Trade Act of 1974, a 10% across-the-board tariff set to expire July 24th. His team called it a workaround. His legal team believed they had bought themselves time. They had not. Section 122 was written for one specific situation, a large and serious balance of payments deficit, and it caps at 150 days. Two small businesses decided to test that. A spice company, a toy retailer. They sued. Thursday night, the court sided with them 2-1. And here's the question almost nobody is asking. If two small businesses can dismantle the most powerful trade weapon an American president has swung in decades, what does that tell you about how structurally broken Trump's tariff strategy actually is? Stay with this, because what comes next is the part Canada needs to understand most. Here is what Thursday's ruling actually exposed. Trump has now burned through both of his emergency tariff tools. IEPA, gone. Section 122, gone. What he has left is Section 232, which covers national security tariffs, and Section 301, which is country-specific and requires a formal finding of unfair trade practices that takes months, sometimes years, to complete. Neither of those tools gives him the power to impose sweeping blanket tariffs on the entire world. The weapon that let him threaten every country on Earth with new duties before breakfast is gone. Struck down. Twice. This is the breakdown you won't get in a 30-second headline. Subscribe now if this kind of analysis is what you've been looking for, because we're doing this every single day. Now let's talk about what this means for Canada specifically, because this is where the mainstream coverage completely falls apart. The 10% global tariff that was just struck down largely exempted Canadian goods that comply with CUSMA already. So this ruling is not a clean win for Canadian exporters. The tariffs that have genuinely been hammering Canada, 25% on steel, aluminum, and autos, those are Section 232 tariffs. They were passed with proper legal authority. Courts cannot touch them the same way. Removing them does not happen in a courtroom. It happens at a negotiating table. And that table has a deadline, July 1st. 53 days from now. Here is the number that reframes everything. Since February 1st, 2025, Canadian exporters have absorbed an estimated $30 billion in direct tariff costs and lost trade. The legal victories are real, but they do not automatically return that money. The refund process for the IEPA tariffs, the $133 billion collected before the Supreme Court struck them down, is already moving slowly. The administration has every incentive to stretch it. Some Canadian companies will wait months, some may wait years, some may never see full repayment. That is why a negotiated deal under CUSMA matters more than any court ruling. Courts strip away the illegal tools. Only a deal removes the legal ones. And with 53 days left on the clock, Trump's leverage is visibly shrinking, while Canada's is quietly growing. The Carney government has not commented on Thursday's ruling. It doesn't need to. The strategy has been the same from the beginning. Let the institutions work, let the facts accumulate, let Trump's overreach correct itself inside the American legal system. While Thursday's ruling was coming down, Canada was confirming fast-track pipeline legislation, reporting LNG Canada's April record of 1 million metric tons exported to Asia, advancing the Bridger pipeline toward 400,000 barrels per day in commitments, and pushing the West Coast pipeline application toward its July 1st submission deadline. Canada was building while Trump was losing in court. That is not a coincidence. That is a strategy. Here is where things stand right now. Trump's emergency tariff powers are gone. His replacement powers are being stripped. His remaining tools are slower, narrower, and far harder to weaponize against an entire trading bloc. The only mechanism that removes the remaining legal tariffs on Canadian steel, aluminum, and autos is a deal. That deal window closes in 53 days. 2 courts down, 1 deadline ahead. Share this with someone who still thinks Trump holds all the cards. Because the cards are disappearing, and most people haven't noticed yet. We track every ruling, every deadline, and every shift at the negotiating table daily. If that's the kind of coverage you want before the mainstream catches up, you already know what to do. Subscribe and make sure you never miss a day.